Corporate and commercial is a transactional cost unit, which is basically dealt with in a transactional format. If you want to appreciate corporate and commercial, we need to just master the art of how things are done and how best we can survive. Because at this point, we are looking at means of surviving. Okay? So, when it comes to corporate and commercial, the question is corporate and commercial transactions. So, when you are revising for basically orals and purposes of appreciating, you need to divide these transactions in according to the way they are categorized. We have what we call commercial transactions and corporate transactions. So we are basically going to start with corporate transactions and later we shall deal with commercial transactions. Corporate transactions include, they are basically categorized into one. That is to say, establishment of business vehicles. Business vehicles include, but not limited to, one, we have partnerships, we have solo proprietorships, joint venture, we have companies. So when you are looking at the corporate transactions, we are basically going to look at the establishment of those different entities. How do you establish a partnership? What type of partnership can be established? Okay, so as a result of that, let us commence with establishment of a partnership as one of our first corporate transaction.
In progress.
Okay, so when we are dealing with partnerships, we are going to follow the following questions. One, what is a partnership? What are the different types of partnerships? Then three, what are the characteristics of a partnership? Then four, how do we establish a partnership? Then four, how do we manage a partnership? And then five, how do we dissolve a partnership? Hope you've noted our questions. Okay, so question one, what is a partnership? Section 2 of the Partnership Act Okay, our question one, it looks at what is a partnership, and we've said that section 2 of the Partnership Act as amended defines a partnership to mean to mean two or more persons carrying on business in common with with an intention of making profits. So when you are given facts, okay, facts are a bit funny, because when you look at a joint venture, on the face of it, it also operates between two or more persons. It operates between two and more. However, the catchword when you are defining what is a partnership, look at elements that make up a partnership. So they will easily direct you on whether the question you are being asked requires a partnership or some other entity. Okay. So under such circumstances, you look at what are the parties intending to do? Are they intending to make profits together? Are they having a business in common? So the catchword is going to be business together and, okay, because when you make reference to the case of Dr. Okello versus Stephen Komakech, how court defined a partnership, okay, the relationship that exists between two or more persons carrying on business in common with an intention to make profits. In a partnership, we basically come together to make profits. Okay. So the business that we're supposed to be carrying on should be in common. Okay. We should be intending to carry on the same business. So when you are given facts, first ascertain whether we are all carrying on the same business. Okay, are we having a business in common? Do you guys hear me? Because Council Jeff is saying that I can't hear anything.
Council, you're loud and
clear.
Okay, thank you. So when you are dealing with it, first break that definition, because once you understand the definition, you can't look any further. Okay, you will easily tell that, okay, the question requires a partnership. Look at the business. Is the business in common or not? Okay. Then our second question was, after what is a partnership, was what are the different types of partnerships? Okay. When you look at the law has established basically three types of partnerships. But in most cases, emphasis is put on two types. The first type is an ordinary partnership. An ordinary partnership is open to all kinds of persons. This is established under Section 2 of the Partnership Act, which is to the effect that a partnership is a relationship existing between two or more persons. When you look at that definition, it is ordinary. It says a relationship existing between or among. That means you can be two people or more than two, provided you're carrying on a business in common. So it doesn't matter whether you are a taxi driver, a hawker, a lecturer, a student of law, a graduate of law, whatever the case may be, provided that you people have come together and you are carrying on a business in common. And when you further look at a section 2, okay, has it limited the number of people? So the number in an ordinary partnership does not exceed 20. Okay, so that means the ordinary businesses, the number of people who carry on business in common should not exceed 20. Okay. Then we have another type, okay, which is known as a professional partnership. When you're looking at a professional partnership, emphasis should be put at section 2, subsection 2, which says that where a partnership is formed for purposes of carrying on a profession, the number of professionals shall not exceed 50. So this means that a professional partnership is only and only for persons belonging to a particular profession. Okay? For a particular profession. So first ask yourself, who is a profession? When you come to section 1 of the Partnership Act, it defines a profession to mean a person who is a member of a profession regulated by the laws of Uganda. So after that, you first ask yourself, how many professionals are regulated by a particular law in Uganda? For you may call yourself a profession, yet you don't have any law that regulates you in Uganda. So under such circumstances, if you aren't regulated by any law in Uganda, you do not amount to a profession. So in the instant case, emphasis can be put to different professions. That is to say, one, the legal profession. Not all persons that fall under legal professions are professions. In the instant case, when we are dealing with a legal profession, we look at those persons who are regulated by the law, and these are advocates. Reason, advocates are regulated by the law known as the Advocates Act and the Professional Conduct Regulations. So their profession is regulated by a law. So that means advocates are fit, okay, to establish a partnership, which is commonly known as a partnership firm, okay? Then another profession that qualifies to establish the same, we have the accountants, okay? We have accountants. We have doctors, nurses, teachers. So all those guys can establish a partnership. Reason, they are regulated by a particular law in Uganda. When you look at brokers for houses, okay, which law regulates them? Okay, so they aren't regulated by any law. Okay, so when you proceed further, we have another type of partnership which is known as a limited liability partnership. A limited liability partnership. When you look at a limited liability partnership, is defined under the Partnership Act, that is to say, Section 47. It defines a limited liability partnership to mean a partnership which consists of two persons, two categories of persons, that is to say, a general partner and a limited liability partner. So a limited liability partner is a partner whose liability is only limited to his or her undertakings. And then a general partner is a partner who bears all the risks and debts of and the obligations of the partnership. When it comes to a limited liability partnership, its establishment, okay, is a bit unique. However, we shall also look at how it is established. So, when you are looking at these partnerships, those three categories, what you should appreciate that all these three categories of partnerships, they have different ways of how they are established. So, the way we establish a professional partnership is not the way we establish an ordinary partnership, is not the same way we establish a limited liability partnership. So, when we are answering our third question, okay, that is to say, how do we establish a partnership? We shall look at how each and every partnership is established. So then we looked, and our third question was, what are the characteristics of a partnership? The characteristics of a partnership can be invoked from Section 2, okay, of the Partnership Act, which says that subject to subsection 2, a partnership is a relationship. So the first one is existence of a relationship. Then a relationship subsisting between or among persons not exceeding 20 number who carry on a business in common. So that means the second characteristic of a partnership is carrying on a business in common, then with a view of making profits. So this means that a partnership basically has three characteristics. So where a question comes, okay, and they tell you that Rashid is a graduate from the Islamic University in Uganda, together with Aisha. Since they are staunch Muslims who believe that the Islamic University in Uganda did more good into them, they have decided to come up and join efforts to ensure that they open up a business which should uplift the status of persons subscribing to the Islamic faith. Yes, we have a business in common. The intention is not to make profits. Okay? So, whenever a question comes, you break it, whether it likes or not. You have to take it on. Okay? Then we've looked at the characteristics of a partnership. Then, how do we establish a partnership? establish a partnership. Okay, so let's look at establishment of an ordinary partnership. How do we establish an ordinary partnership? Okay, okay. So when you look at section 4 of the Partnership Act, gives you the requirements. Okay, it is to the effect that any firm carrying on business in Uganda under the business so that means because the law requires that you should have a business name. Okay, so you can't establish a partnership when you don't have a business name. So the first requirement or the first step in establishing this entity is by coming up with a proper business name. So ask yourself, when you are coming up with a proper business name, ask yourself, what are the things you should put into consideration? Okay. The things you should put into consideration. Okay. So when you look at the things you should put into consideration is one, a business name should not be a misleading name. Then it should also be a desirable name. The question for determination, what amounts to a misleading name and what amounts to a desirable name. A misleading name is a name that on the face of it you can reasonably think that it is another entity. When you can rely on the name, because you have people who buy products on grounds that they are coming from a particular person. We have people who eat food in some restaurants here, we know, because there is a particular waitress. So when you establish an entity, okay, and you establish it, you come up with a name, which on the face of it is misleading. Someone may reasonably believe that this name is for another entity. The registrar will decline to register such a name. Then non-desirable, it should be a name which is not disgusting in the society. Okay, I've always used the example of Queen Masoro Beauty Center. Okay, because we understand Bad Black as one of the highly appreciated persons in that field of selling beauty products. So under such circumstances, you'd be able to appreciate the fact that she can't use that name. Reason, the name is undesirable. So now, we presume that you have come up with a desirable name and it isn't misleading. The second step will be making a search to the registry and ascertain whether the proposed name is taken or is available. This search is done by way of an ordinary letter. We write to the registrar to avail with the particulars they are under. Then we presume that you have written and the name is available. Then you proceed and do what we call reservation of business name. The reservation of this name takes place. It has a lifespan of 30 days. Once you reserve this name, no one will be allowed to register any entity under that business name. Then after you have reserved, the next step will be registration of a business name. So once you register your business name, now you are at liberty to utilize your name. So now, at this point, you have a business name, but not the partnership. So now we want to form the exact partnership. When you read the case of Dr. Okello versus Stephen Konamakech, court held that there are two ways of establishing a partnership. That one is in a contractual form by signing what we call a partnership deed. Another one is by implication, where conduct of the parties. Court may imply from the conduct of the parties that there existed a partnership. Okay. Okay. Thank you, Council Hafswa, for the efforts. Okay. So let's proceed. So when you look at the two modes of establishing, so that means after you've gotten a business name, if you are going with a partnership deed, you will proceed and draft a partnership deed. So ask yourself, do you know how to draft a partnership deed? Its contents. Okay. Do you know the contents of a partnership deed? If they ask you to draft that document orally, can you survive in orals? Okay. But you have it in your book. I know now you people are checking on that on your partnership deeds. Okay. But I'm very sure you are not pleased with it, because by the time you did it, you were professional advocates. Okay. So now, when you are drafting a partnership deed, remember this is going to be a public document. You start with the Republic of Uganda. This is a relationship existing between two or more parties. The reason why you are putting it into writing, you have an intention to be legally bound. Then you proceed and you say in the matter of the Contracts Act. Then after that, you put in the matter of the Partnership Act. Okay. Then you have a name. You can also put, you say in the matter of Twekoye Enterprises. Okay. Then you say partnership deed. This deed is made this 24th day of this and this between Aisha Naseje and Bidandi Jeff. It is hereby witnessed as here under. So whatever you include from that point, okay, whereas both parties are carrying on or intend to carry on a business of fishmongering with an intention to make profits, they have agreed as here under. One, talk about partnership property. Then 2, talk about management. Then 3, talk about liability. Then 4, talk about introduction of a new member. Then 3, talk about expulsion of a new or sort of an old person. Then 4, talk about sharing of dividends. How are we going to share our money? Okay. Then talk about liability of court process. Then you can also talk about how it can be dissolved, how it can be varied, and then also you talk about how it can be dissolved. Okay, etc. So we presume that you have drafted your deed. Okay. Upon drafting this deed, remember, we are humans. Okay, we are humans. Some of you, they have caught you with messages in your phones. Okay, the message says I'm pregnant. Say John. How did John start conceiving? Okay, but you saved the number as John. Mukwano gwange John tukola naye akayerabidde weerabize n'agisindikira nsi. Okay, neerabira nali nakuteerako John's wife. So we can easily kwegana. So as a result of that, what is always done, we proceed and we do what we call registration of the partnership deed under the act, the law known as the Registration of Documents Act. So now, after registration of that, the partnership deed becomes a binding document. Then after, since we have an intention to carry on a business in common, we can't carry on any business without a valid trade license. Then we proceed and we go for obtaining of a trading license. For you to appreciate the same, I want you to refer to the case of Uganda Law Society versus KCCA. You'll be able to appreciate the same, inshallah. Okay? So, under such circumstances, once you obtained a trading license, you have fully established your partnership and it can easily commence work. So now, once a partnership commences work, the biggest challenge will be in management. So then that takes us to what we call management of a partnership. When you are dealing with management, first thing you need to appreciate, what do we manage in a partnership? Okay. What do we manage in a partnership? In a partnership, we basically manage the following. 1, partnership property. 2, liability. Then 3, partners themselves. Okay. So when we are dealing with management, we have we're starting with management of partners. Okay, so you ask yourself, when it comes to management of partners, the general rule is, in a partnership, every partner is an agent of the other. So for you to effectively manage the partners, you have to first appreciate who amounts to a partner and who is not a partner. This is basically done through what we call understanding rules governing existence of a partnership. This is under section 3 of the Partnership Act. It is to the effect that when you see a couple of things on the face of it, it may look to be a partnership. However, mere existence of such evidence doesn't make it conclusive that it is a partnership. So the simplest way you can appreciate section 3 is by basically putting into consideration our third question, which was what are the characteristics of a partnership? What are the characteristics of a partnership? When you read section 3, okay, it shows you the different things which on the face of it may look to be a partnership. However, when you dig deep, okay, it is not a partnership. Reason, they don't have a business in common. 2, no relationship. 3, they don't have any intention of making profits. That is the catchword. Okay. So let's, I don't know how we can read section 3, but let me just highlight for you a few things. For example, 1, they are talking about having a receipt from a partnership. This means that 1, we have borrowers who always borrow us money. These guys, they can effectively receive receipts as proof of payment. However, in such circumstances, you would be able to appreciate the fact that in such circumstances, we don't have an intention of making profits with the money lender. He just borrowed us money Okay, so when you are reading section 3, just make sure your emphasis, you for example, look at section 3, paragraph A. Joint tenants in common, joint property or common property does not itself create a partnership. Why? We jointly own property together, but are we intending to make profits together? So what is missing? The characteristics of a partnership will always be missing in section 3. So they'll give you facts. You apportion liability on someone who is not a partner. Okay. first appreciate, is this person a partner? Okay. Under such circumstances, you should also look at people holding out to be partners. Someone holding out to be a partner doesn't in any way benefit the partnership. So when you are apportioning liability, you should be keen with such circumstances. Okay. Then after management of partners, under that very thing, you should be able to appreciate what are the different categories of partners we have. Okay. We have minor partners. How do we manage them? Okay. Are they liable the same way we are liable? Also have to look at relatives, okay, of our partners, because we have to manage these guys. So on that same line, we have to appreciate what we call introduction of a new partner and expulsion of a new partner. Because someone may be with us when he's not a partner, but when he's carrying on business under our name, and at the end of the day, we shall be liable. So, as a result of that, it's either prudent we recruit him or her, or we expel someone he or she has been dealing with. Okay. So let's first look at introduction of a new partner. The rule is under partnerships, everything is done by consensus. A mere majority cannot allow, okay, introduction of a new partner. But what is required? You have to look at the partnership deed, okay? You have to look at the partnership deed and ascertain whether the partnership deed allows that all partners should consent on admitting a new member on board. So the general rule is it is on total admission. All partners should have admitted this person. Okay. Then we have expulsion of a partner. The same way we add a member, it's the same way we expel. When you look at section 27, it says the majority of the partners have no power to expel any partner unless the power to do so has been conferred by express agreement between or among the partners. This also implies that to expel a partner who is misbehaving, it should exist in a partnership deed. That's why they say it should be expressly agreed upon, because something expressed is something that is written. So in always they can give you facts where you've already seen a question somehow. It says that Wambuga, Gerard, and some other person are partners. However, Wambuga has approached Gerard and complained about his poor conduct. He has told him he will never change. Let him go and curse. Okay? That partner is misbehaving. Yakugambye genda kale ekolima nesijja vaawo. Okay? So, are you going to tell him to weeyisa bigenda? You can't. You go back to the partnership. So the question requires expulsion of a partner who is misbehaving. But they want you to advise them on how to expel that partner. Okay? So they should go back and visit their partnership deed to ascertain whether this person signed okay, on the partnership deed, and they look at what we call expulsion of a partner. So that means under that clause, you should include things you may rely upon to expel a partner. Okay. So now that is, we have managed the first category of management. Then let's go to partnership property. The general rule is upon establishment of a partnership has no corporate personality. Okay, it can't buy property. Okay, but how does it own property? Property comes from you, the partners. Okay, so when you look at the Partnership Act, it literally provides for two ways how a partnership can acquire property. Okay, Section 22 of the Partnership Act says that all property rights and interest in a property originally brought into the partnership stock or acquired. So that is the first one. Okay, originally brought. So that means when the partnership is starting, that's what we call property originally brought. Once you guys are going to ejaculate curtains and they talk on CP, okay, that means you have brought property. Once you bring originally, that property becomes partnership property. So that's one. Then when you proceed, the same section says whether by purchase. So that means we can also purchase property, but using partnership money. That means after the partnership has commenced, it will start making profits. So we may argue that these profits are reinjected back in the partnership by buying partnership property. So that means a partnership acquires properties in two ways. So ask yourself, the partnership has acquired property. How is this property appropriated? Okay. How is this property applied? Okay. When you look at section 22 subsection 2, it tells you that partnership property must be applied equally and exclusively by all partners. What does that mean? No person has legal ownership. Okay. And everyone has a right to enjoy it. You know, when we were growing, we used to play football. Naye ng'agula omupiira mwana wa mugagga nga bagamba bwe munkubako nga ngutwala. Okay? Nga ye tebamuwa red card ye ne bwazannya bubi guba gugwe. Okay? Ate nga yalonda ne ttiimu ng'alonda abamanyi n'abateeka ku side ye kati mwabatu. Okay? Why? You couldn't apply that property exclusively. But if we had solicited bibiri buli omu, we could have bargaining. We could apply it exclusively because we all contributed. But regardless of the fact that we looked at ourselves as a team, we were not. So the same thing that applies here on partnership property. Okay. So they will give you facts where partnership property is applied by one person. Nga bw'atabaawo emmotoka ya partnership tevugwa. Okay. Why? That is breach of a partnership. It can lead to termination because it is no longer a partnership. Okay. So be keen with the oral questions. Okay. Then another thing we look at in management is what we call liability. Is what we call liability. Okay. So now, liability. So when you are dealing with liability in a partnership, liability is apportioned in different ways. What you should note, we don't apportion liability to a person who is not a partner. That's why we first look at management of persons, of the partners. We exclude those who aren't partners so that whatever comes should be dealt with accordingly. Okay? So we want to apportion liability, but to only partners. So the first category of liability we are looking at liability of minor partners. Liability of minor partners. Okay? Regardless of the general rule is that all partners are jointly and severally liable. We have partners that aren't liable the same way. Why? Okay? When you look at the Partnership Act, the general rule is colleagues, I've received the message from Council Aisha that she's going to log in to first ascertain the membership of the group. Okay? Those that are doing supplementary, kindly inbox me. Okay? Okay? So, when you look at the Partnership Act, okay, it is very clear, okay, on how to apportion liability. So, when you look at the general is minors have a right to contract, but provided the contract is of necessity, as it was in the case of Nash versus Inman. So if this minor entered into a contract, okay, for purposes of necessity, and you want to apportion liability on this minor, then you are unfair. Okay? So what happens? When you read the Partnership Act, it says that minors are not liable, okay, are not liable until they attain majority age, until they attain majority age, okay, until they attain majority. When you look at section 10, okay, it says that minor partner not personally liable for the firm's obligation. Remember, I said that the general is all partners are jointly liable. You know why? A partnership has no personal capacity. Okay, it has no the corporate personality. So the partners will be liable. So, but section 10 excludes a minor from being personally liable, because it says that a person who is a minor, according to the law to which he or she is subject, may be admitted to the benefits of the partnership, but cannot be made personally liable for any obligation of the firm, but the share of the minor in the property of the firm. Okay, the property of the firm will be liable. Okay, okay. So let's look at the first one, seen liability of members who are minors. Okay, then we have what we call liability in circumstances of wrongs. Okay, so but what you should note is that section 12, 13, 14, 15, and 16. Okay, they basically deal with liability of partners. The general is all these guys are jointly liable. However, we have circumstances where these guys will not be jointly liable. Okay, this implies that you should be able to understand, okay, what acts make a partner to be solely liable. One, misappropriation of the partnership funds. You have used the partnership money for your personal gain. You have okwanjula, you have okuchala, you are broke, and you being broke, you decide to use our partnership property as, okay, our partnership property as security. Okay, so that you get money. So you invite us on your wedding, we eat food. At the end of the day, we realize that we are eating our money. My dear, you will pay on individual basis because you applied partnership property without our consent. Okay. Then also where you make a mistake when you are not in line of duty. Remember, the general rule is a partner is an agent of a partner where you are in line of duty. So where you are on your own peril or your own frolic, we shall not be liable. Okay. Then also where judgment is entered against, okay, so where judgment is entered against a partner in an independent suit, okay, which is not part of the partnership. So under such circumstances, we do not risk, okay, get your own problems, solve your own problems alone. Okay, so under such circumstances, we do not in any way risk the partnership property. Okay, okay, okay. So are we together? So when you, the first thing you have to appreciate is apportioning liability. Okay. So when it comes to liability, it seems we have dealt with it. Okay. So now, also maybe we have liability of persons holding out. Once you hold out, you will be personally liable. Okay. You'll be personally liable in such circumstances. Okay. So then when it comes to Jemba. No, unamleke na Brenda. Muleke. Okay. So when you look at again on liability, okay, when you look at the current system, it has a requirement that in any business entity that has been registered, you have to file what we call a register of beneficial owners. Okay, so any partnership, once it is registered, you have to first give us the register of beneficial owners. Who are the persons who are going to enjoy from your your proceeds? Because we do not want to have issues with persons. Okay. So are we together? So now, when you look at that, our business is moving. Okay. We deal with we know the relationship with people who are not part of us, so everything is moving on well. However, emphasis should be put, okay, on section 25, also on liability. I have hit about it where it says that procedure against partnership property for partners separate judgment date. So where a partner, okay, is having judgment, okay, separately, which is not part of the partnership, you have to be individually liable. Okay. Then we know who are the partners now in our partnership. We know their liability. Okay. We know everything, how it is moving. Okay. So at this point, there are things we should put emphasis on. All the partners we have, they are compliant, they are doing things the way they are supposed to be done. Then let us ask ourselves, what are the rights of these partners? That takes us what we call rights, okay, of, okay.
Answer Rashid.
Yes, counsel.
Kindly help me recall that part of beneficial owners. I kind of skipped that.
Yes, yes. When it comes to partnerships, okay, companies and other business entities, The current amendment requires that you should file what we call a register of beneficial owners. This register helps the government to track people who should benefit from your proceeds. That's what we call beneficial owners. Okay, so we've said that at this point, okay, we have our partners, everything is moving on well. So what are the rights that these guys should enjoy? That takes us to rights of partners. Okay, one, they have a right to access books of accounting. That is under section 30. Then another one, they have a right to assign their share in a partnership. You may be tired of the partnership, so the law allows that you can assign your interest to some other person. Okay. Then you also have a right to retire from the partnership. Okay. Tebagikusibyeko. Once you feel like you're tired, please retire and go home and relax. Okay. Then another right, you have a right to engage in management of a partnership. When you look at the case of Dr. Kello versus Stephen Komakech, where court held that we have two types of partners, active partners and dormant partners. Active partners, those are the ones that actively participate in the management of the day-to-day running. Then the dormant ones, they give directions basically. They don't actively participate because in a partnership, we don't have a boss. Okay. Then you have another right. You have a right to share on the returns stroke remunerations. Okay, so you should appreciate that because they can ask you, so what are the rights of? Okay, now in circumstances where these rights have been violated, what okay, what remedies are available to a partner whose rights have been violated? Okay. Sorry. Oh. Okay. So we've been looking at the remedies available to a partner whose rights have been violated. Okay. Then that takes us to what we call dissolution of a partnership.
Council
Okay.
Shege,
Council, we didn't hear anything
we
about
didn't hear the
the
remedies.
remedies.
It's counsel.
We didn't hear anything about the remedies.
No, we're just starting on them. Say that now these rights of this partner have been violated. Okay. So what are the appropriate remedies? Okay. This partner has. So where your rights have been violated in a partnership, you have the first remedy known as retirement from a partnership. Okay. You can retire. Nedda. Okay. What else? Okay. So retirement from a partnership, because you cannot really work in an environment which is toxic. Okay. So if these guys don't like you, leave and go. Okay. So when you look at section 28, says that where no fixed term has been agreed upon for the duration of the partnership, any partner intending to dissolve the partnership shall give reasonable. So where we call you can proceed under section 28. You give these guys the notice that you know what, I'm leaving. Okay, I'm leaving. So that means the remedy you have is retirement. Okay. Then, but retirement has conditions. One, we have retirement by notice, where you have to notify the other partners so that they effectively prepare for your retirement. Okay. Because sometimes people may not be okay with your retirement. Okay. Okay. Are we together? Okay. So you either, if not that, you obtain consent, okay, from the partners. Okay. But the partners may incline from giving you consent. Okay. So you should put emphasis on that. Then you have circumstances where the very partner we are talking about, instead of the partnership violating his or her rights, this guy is infringing on other partners' rights when this guy is misbehaving. So the remedy available is expulsion. We expel him from the partnership, okay? Under section 27, we expel that partner, but it should be subject to what we agreed upon in our memorandum. That 27 talks about expulsion. Okay. Then, if not that, we shall agree if things are not working out well, and we go for what we call dissolution of a partnership. So that takes us to what we call dissolution of a partnership. How do we dissolve a partnership? When you look at section 34, okay, and other provisions that do follow the subsequent provisions, they provide for the different ways how to dissolve a partnership. Okay. One is by influx of time, where a partnership was for a particular period of time. Okay. And you perform such tasks within the specified time, we dissolve. Okay. That is dissolution by influx of time under section 34. Okay. Then another one we have by agreement, where the partners sit and agree and they say, let us dissolve this partnership, where the business no longer works the way they expected. Okay. The way they expected, so they can agree and they dissolve the said partnership. Then another one, where upon performance of the specified undertaking, where it was for a particular act and the act has been performed, we can proceed and dissolve. Reason, the business in common we agreed upon has come to an end. Okay. Then another one is by an illegality, where the subject matter you've agreed upon has been declared an illegality. Let's assume you entered into a partnership when you are trading in gold, okay, or you are trading in cryptocurrency, okay, and under such circumstances, cryptocurrency has been declared illegal in Uganda. So if it has been declared illegal in Uganda, it is clear that whatever you are carrying on is illegal. Okay. It is not allowed in Uganda. So under such circumstances, your partnership has no legality. Okay. Reason, what you are trading in is an illegality in Uganda. Then we have dissolution by death. The general rule is death doesn't dissolve a partnership. However, where it was expressly agreed in the partnership deed, death will dissolve a partnership. And then where the partnership is of two people, basically, death will automatically dissolve the partnership. Okay. Then we have what we call dissolution by bankruptcy or lack of capacity. Remember, the general rule is a partnership is a contract where someone loses capacity to contract. Either this person becomes a person suffering from a mental illness. If not, this person is declared bankruptcy. That person loses capacity to contract. So automatically, the partnership shall be dissolved. Okay. So now you ask yourself, what is the duty of the former partners upon dissolution of a partnership? Or what is the duty of the partners upon a particular partner leaving a partnership? Okay. Because remember, partnership deals with the society. Okay. So under such circumstances where a partnership has been dissolved, the former partners have a duty to file with the registrar what we call a notice of cessation, indicating that the partnership has ceased to operate So no person should have hope of dealing with the said partners in any way. Okay. So as the partners, you see, during my orals, Council Chinowe Simon Peter asked me that question. The first question he told me that, Rashid, we are three here. We own a law firm. Okay. But you see her, she's pretty. She has gotten a scholarship at Harvard, but she has been our mastermind. Advise us on the available options. So one, I say she can retire from the partnership. Okay. And he was like, okay, she has retired. How will we notify the public that she's no longer part of? Okay. So that's the duty of partners after one partner has left. We call okay, issuance of a notice of retirement. You issue a public with a notice indicating that a particular partner has retired from the partnership. So please don't deal with that part. Same applies to okay. Same applies to expulsion or admission, because the society has to know the people we are dealing with. So where you expel a partner, you notify the public. Where you admit a partner, you notify the public, because we have to know the persons we are dealing with. Okay. 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 So are we together there? So then another emphasis I need you guys to look at what we call liability of outgoing partners and liability of incoming partners. Okay. Where a partner has left the partnership, is this partner still liable or not? Okay. Where a partner has left the partnership, okay, is this partner still liable or not? If yes, to what extent? Okay. So let's look at liability of outgoing partners. When you read the Partnership Act, it is to the effect that an outgoing partner is only and only liable, is only and only liable is only and only liable to the liabilities that accrue when he or she was still a partner. So the liability that you guys get, okay, when he has ceased, he is not liable. But those that he incurred when you guys are still together, he's liable. There is a question you saw, it was about a law firm still, okay, which says that you have just joined us in a firm. However, we have the following challenges. Okay. Counsel Aisha, when she was still a partner here, she called the ICT specialist to assist us with establishing a website, okay, for the firm. After the ICT specialist established the website, Counsel Aisha was appointed as a magistrate. The ICT specialist is still demanding, but Aisha is no longer picking our calls, advice. The question was testing. One, Aisha is no longer a partner. However, she hired the ICT specialist when she is still a partner. So that means she is still liable for that debt. That is a debt that accrue when she is still a partner. Okay? So the same thing to the incoming partners. Incoming partners are not liable for liability that accrue when they are not partners. The day they join the partnership is the day they start being liable. Okay? So put that into consideration. Okay? So any question? The thing I've left out that I want to go back, I bring is establishment of a professional partnership. But I've covered partnerships. Any question? Okay? Apart from questions relating to establishment of a professional partnership. Any question?
Council, kindly provide us with a section which says that members are not liable for the acts that arose when they are not in the partnership.
Okay, yeah, let me see. Let me get it here for you. Okay. Look at section 9, council. Okay. And also look at death. Hey, look at death and bankruptcy. My dear, even if you die, okay, when you are still liable, okay, we shall hold you liable. Okay. Once you die, the debt does not die. Your estate will be liable. So they can give you facts where a partner died, okay? But this person has an administrator. But upon death, this guy had debts in the partnership. Because for you read the law and say, death dissolves a partnership. My dear, death does not dissolve a debt. So your estate will be liable to pay the debt. Same applies to a person declared bankrupt. The receiver has to first receive and pay us. Okay? We are unsecured debtors. Oh, sorry, unsecured creditors. Okay? So put that into consideration, because when they are asking things in partnerships internal. So this implies that the things they're supposed to be asking you, those things that someone may not put emphasis when reading, those issues of liability of a minor, outgoing partners, incoming partners, okay, how to appropriate partnership property, admission, expulsion, okay, retirement, because they know when you are reading, emphasis is little, okay, on those, because all of you, you know how to establish a partnership. So they can't ask you that. But they know you don't know how to do what you call a cross-border practice. They can ask you that. Okay? But they know everyone at this time is going to read establishment of a law firm. But a few people will understand what we call a cross-border practice. So put that into consideration. Okay? So, any other question, Council?
Councillor Sweet,
Yes?
may you please throw some light on the partnership, the liability partnership?
Limited liability partnerships. Okay?
Yes.
Those ones are also left with their establishment only. But liability, what everything, the partnerships are the same. That's why I had to first go through those. Then we just come back, because these are just particular provisions like 223. that talk about establishment of these partnerships. Okay. So let's first start with establishment of a law firm. When you look at establishment of a professional partnership, our emphasis is going to be on a law firm because that's what we know and that's what we are. Okay. So when you look at Article 40 of the 1995 Constitution, it says every person has a right to participate in his or her profession or business of his or her own choice. Okay. So as a result of that, you ask yourself, who is a profession? You come to Section 2 of the Partnership Act. A profession is a person who qualifies and is regulated by the laws of Uganda. So the first thing you do when they give you facts, first ask yourself, are all these legal professions or they are legal rebels? A legal profession amounts to an advocate. So the first thing in establishment of a professional partnership is enrollment as
Shady, we are not hearing.
okay. So we've been looking at establishment of a partnership of a partnership which is a profession. So we've said that one, first establish that these guys are professionals. They should all be advocates. Okay. They should all be advocates. So when you go to Section 2 of the Advocates Act, it defines an advocate to mean a person whose name is duly entered on the role of advocates. Council is Article 40. Okay. So as a result of that, first ask yourself, have these guys enrolled? Okay. Are they on the register of on the register of advocates? Okay. The register of advocates. Then ask yourself, how does this person become an advocate? Then take us to the process of enrollment. So enrollment is a case-to-case basis. The rule is for you to enroll, you should be in possession of a valid certificate from the Law Development Center okay, indicating that you passed the bar course that you guys are battling with right now, okay. So if not, it's equivalent from a recognized institution, okay. Okay, so when you look at that, so the presumption is this person has a bachelor's degree, you qualify. Two, you have passed the bar course or its equivalent. As a result of that, okay, you make your application to law council, you support it by an affidavit, okay. You support it by an affidavit, which is supposed to be registered. Then after, you'll be issued, yes, an application for enrollment. It is supported by an affidavit, of which the affidavit you should attach a copy of, okay. You attach a copy of recommendations. We have what we call a professional recommendation and the employer's recommendation. The profession, you attach a copy of one of your PAs at the Law Development Center who recommends you, okay. Then after that, you also attach your employer. Where are you employed currently? Okay. So then after that, you pay subscription fees of 50,000 for the application. Okay. For the application. Then after that, you will be glad they'll issue with what we call a notice of enrollment. Once you are issued with the notice of enrollment, you have to gazette it. After gazetting, you take it back, your name will appear on the list of persons to be enrolled. Once you are enrolled, you will be issued with a certificate of enrollment. Once you get the certificate of enrollment, then you will be able to apply to receive what we call a certificate, a practicing certificate, which allows you to practice, okay? And that will imply that now you are an advocate who is regulated by the law. That means you qualify to establish a professional partnership. Then we start establishing a professional partnership. Unlike the other partnerships, this one has to type.
So excuse me,
Yes. Yes.
I have not had something to do with making a petition to the Chief Justice. Where does that thing arise? Because I remember us covering it in class.
That's what we call a petition for a certificate, a practicing certificate.
Okay, thank you.
But I've just used the word apply because the word petition means applying in law. Okay. So now we presume that you are an advocate now and you can proceed with establishing. So now, as a result of that, you first proceed and get your other colleagues who are also professionals, okay? Not lawyers, only advocates, okay? So as a result of that, you proceed and look at the names, establishment of a name. So when you are formulating a name of a law firm, the following things should be put into consideration. Okay. One, a name of a law firm should not be affiliated to any religion. Two, culture, political entity. Okay. It shouldn't be affiliated to that. For example, you say blood of Jesus advocates. So Faba Muhammad Imam Tugobye. Okay. People power advocates. Okay. So Manchester United advocates. So when you look at that, those names are prohibited. Then if you are intending to use your true surnames, you can use even initials. For example, okay, you are two, that is to say Afwa and Aisha. You can say AA advocates, because you are allowed to use your surname or your true English name or their initials. You are Afwa and Aisha. You can say A and A advocates. Okay. If not that name, you can use what we call generic names. A generic name is a name other than your true surnames. Okay. A name other than your true surnames. Check on your phone. Okay. Other than, okay, your true surnames. Okay. So these are funny names. A generic name is that name you wake up and they say, let me say, Kadesh advocates. Because you and your girlfriend, you've agreed to start up a partnership. You are all advocates from the Law Development Center. You decided to come up with a partnership. Okay. You agree. Okay. So because love is at the climax, okay, you are Aisha and Jeff. So you say Ash Jeff advocates. Okay. So as a result of that, you are using the generic, but not all generic names are allowed. So if you are intending to use a generic name, okay, you first make an application to the law council to approve your generic name, because you have generic names that are not allowed. Okay. Okay. So are we together now? So now we've gotten your name. It is either generic or your true sir. So once you've come up with the name, or you've made an application to the law council and it has approved use of a generic name, okay, then you proceed and you go for what we call registration of the name. That one we know. Okay. Then after, you know, the process of registration, you do a search, you reserve and register. Then after registration, you proceed and start establishing your office. But the standard of your office is controlled by the law known as the approval of chamber regulations. So your chambers have a standard format. They should have space for the advocate, the secretary, waiting area, resting area, a set of computers, etc. So you first put all of those together, and it should be in a conspicuous place, not in turning okay, not in a noisy place. So after you've established, you think you have established, you make an application for inspection of chambers. It is by an ordinary letter addressed to the law council. Okay. So once you write a letter for inspection, the law council will send the inspector to inspect your chambers. Upon inspection, and they realize that your chambers are on standard, they will issue with what we call a certificate of approval. Your chambers will be approved. Once your chambers are approved, you do not need to get a trading license. You automatically start and commence business. You automatically start and commence business. Reason: the law relating to professional advocacy does not require payment of trading license dues, as per the case of KCCA. Okay, that is Uganda Law Society versus KCCA. So as a result of that, you would have established, okay, your professional partnership and commence business. Any question? So when you look at what we've been looking at, is what we call a professional partnership. So this type of big commercial is not, okay, it is a corporate transaction. We've not seen exchange of money that give me money, I do this. No. That's why it's called a corporate transaction. Okay. Any question from partnerships? We want to cross to company. Okay. Any question? We want to cross to company. Yes,
Excuse me,
Council.
Council.
Yes,
Council
yes, go
Rashid,
back. Yes.
before we proceed to companies,
Okay.
it is my humble request that we handle cross-border.
That's the one I've been waiting for.
Thank you.
But Council, which gadget are you using? You're proceeding in chambers. Okay. Yes, Council Ronald.
Me, I just wanted to know. They told us about it, but I forgot how to go about it. How do you register a partnership property under the
Now,
partnership? If, for example, different partners are contributing property, how do you transfer it from there?
What you do, you just register as co-owners or joint owners, because a partnership can't be entered in a certificate of title. Okay. Okay, Council Rebecca has talked about cross-border practice. Cross-border practice is a case-to-case basis. What you should appreciate that cross-border practice currently is governed by what we call the East African Common Market. When you read the East African Common Market, it provides for what we call free movement of labor. However, we are not providing labor, we are providing a service. So as a result of that, once you have a matter in other jurisdictions, you are required to obtain what we call a special practicing certificate in regards to that matter. And that certificate will clearly specify, okay, what you will handle, when, and from what court. That is the only way you can do cross-border practice. But this issue of smaller common markets, my dear, doesn't work. Ask those people who deal in trade, okay, when they cross to Tanzania, okay, when they cross to Rwanda, how they are treated, okay. So in practice, when it comes to law, you obtain what you call a special practicing certificate. It is only valid for that matter you are appearing in. Maybe also counsel try to appreciate how persons do enroll who have been from different jurisdictions, how they enroll, okay, from common law countries and non-common law countries. How do they become advocates in Uganda? Put emphasis on that as well. Any other question on partnerships? Yes.
I beg you, throw more light on that. I've not
On what?
appreciated well.
On what, counsel? We've said the general rule is, okay, the general rule is when it comes to East Africa, we have what we call the East African Common Market. Under the East African Common Market Protocol, the protocol says that we have free movement of labor. You can wake up, you go to Kenya, you work and come back. That is the presumption. But lawyers, advocates don't provide labor. They provide a service. So since we are providing a service, we don't fall under that. We just make an application, okay, to the law council of that country, okay, which will be endorsed by the Chief Justice, and you get what we call a special practicing certificate. That special practicing certificate shall only be in regards to that matter, okay? Shall only be in regards to that matter. Once the matter has come to an end, that's where everything ends, okay? Your special practicing certificate would also have come to an end. That is it, counsel.
Much obliged, counsel.
Counsel Rashid.
Yes, counsel.
I wanted to ask. I just wanted an elaborate to elaborate on the beneficial ownership as regards to limited liability partnerships.
Okay. Beneficial owners register. Remember, in a limited liability partnership, okay, what exactly happens is that in such circumstances, people earn according to their liability. The more liability, the more you earn. So as a way to trace who are the people who benefit from your proceeds, the law requires, it makes it mandatory for you to register all beneficial owners, people who intend to benefit from your proceeds. Actually, it is a way of fighting corruption and money laundering. That's why they established that until it's mandatory. Because you may find that the end consumer of your product is a terrorist. Okay, so as a result of that, you have to register the same. Okay. Any other question? Yes.
Council, who endorses on the application for a special certificate?
You apply to the locals of that country and the Chief Justice will endorse.
Okay.
Council is talking about a post-call backwards application. That's what I was telling you, that people try to look at what we call how people from other jurisdictions, okay, enroll. People from jurisdictions other than common law countries are the ones that go for a post-call backwards. What does this mean? Because when, for example, when you look at people who seem to have enrolled from Rwanda, when they come here, they go for a post-call backwards. They are told to do the COAs, those procedural course units. You do civil, criminal. Those are the first COAs. Okay. You do evidence or want what? Depending, because those are the COAs of the common law country. So once you pass them, IABAS. Okay. Any other question? Yes. Okay. Any question? So let's take a break of 5 minutes. We switch to company. Okay. In exactly 5 minutes, we're going to be switching to company. So prepare your minds, get the Companies Act and its amendment. Thank you, Council. Okay. We've said that at this time we are looking at what is a company, and we said section 2 defines a company to mean a company incorporated under the Companies Act. Then after understanding what is a company, you need to ascertain what are the different types of companies, because they'll give you a question which require to advise your clients on what appropriate entity you have to establish. But that entity, basically, emphasis should be made on the different types of companies, because clients will always come with a different view. Okay, so we have what we call a private company and a public company. A private company basically is defined under also section 2 of the Companies Act. Okay, Okay, so a private company is a company which limits transfer of its shares to the public. It is restricted to a number of 100 participants. And again, a private company, basically what you should know, it does not deal with anything concerning the public. So at LDC, basically you people deal with the private companies, not public companies. Okay, it doesn't invite the public, it restricts transfer. So once a company okay, members, do you hear me? Someone is saying that my volume is off.
You're loud and clear.
Okay.
You're very clear.
Okay, Cancer. Okay, so when you look at that, a private company, but under private company, we have what we call other categories of private companies. And this, we have a limited liability company. When you read section 4, subsection 2 of the Companies Act as amended, it defines a limited liability company to mean a company whose liability is limited, okay, by the memorandum and articles of association, okay. And under,
Pardon on that, no?
okay, section 4, subsection 2 of the Companies Act as amended, okay. A limited liability company is a company whose liability is limited, okay, is limited by its memorandum and articles of association. Okay. Then, when it comes to limited liability companies, they have 3 types. Okay. They have 2. We have a company limited by shares and a company limited by guarantee. So we shall start with a company limited by shares. Again, section 4, subsection 2 of the Companies Act defines a company limited by shares to mean a company whose undertaking is limited. Okay. Your liability is limited to the amount of shares unpaid up. Okay. To the amount of shares unpaid up. What does that mean? That where it is a company limited by shares and you have subscribed that you shall take 50 shares and you pay the entire shares at once, you are not liable. But where you've paid 20 shares and the balance of 30 is not paid, okay, you will be liable for the payment of the balance. So your liability is only limited to what we are demanding you. That's what you should note. Okay. Okay. Then a company limited by guarantee is also defined under section 4, subsection 2. It says that a company limited by guarantee, okay, is a company where liability is limited to your undertaking. Basically, the undertaking can be referred to as a pledge. What you pledge to give us, that is your undertaking. So that implies that when we are in a company and that is the mode of proceeding, okay, your liability is limited to your undertaking. That's why when you are starting an NGO, okay, you establish a company limited by guarantee, because in an NGO, you go for what we call an undertaking. That to me, I'll be helping the pupil with this. So your liability is only limited to that undertaking. Okay. Then the second category of a private company is what we call a single member company. Section 2 of the Companies Act as amended, as well as read together with the single member company regulations, it defines a single member company to mean a company which is owned by a single member. Okay. To mean a company which is owned by a single member. So when you look at those, we have different circumstances under which, okay, those companies can be established. For example, someone entered on the panel and they told him, Council, I want to start up a company, proceed. This guy is the word I, okay? I want to start up a company, proceed. He said I, but not we. So if you are not sober, the question goes for establishment of a single member, because he said I, and when you read section 4, says that anyone or more persons may for a lawful, so you go with anyone, a single member company. But where the panelists, they tell you, Council, we want to establish, he's using we. So the appropriate answer will be a limited liability company for more than, okay? But where he says I, what does that imply? Himself only is the one who wants to establish the company. So when you enter, the question comes, okay? Again, from that very position, I have a question I saw on the platform, okay? That question was tricky. They told you that Council McDonald wants to establish a company in Uganda. Advise him, okay? Advise him. That question is tricky. Why? McDonald is already an established entity in South Africa, okay? But they have said McDonald wants to start, so we don't know, okay, whether it is McDonald as an individual or McDonald as a company. So where a question is like that, you discuss two positions. You first tell them, let's assume that McDonald once established an existing company, because you have knowledge about that. So you discuss the process of what we call incorporation of a foreign, registration of a foreign company here, okay, or establishment of a subsidiary company, okay, okay. If not, you advise him to establish a foreign company. Remember, you can establish a citizen company or a foreign company. So you should put, and they said he wants to establish a company, him as a person. So it was calling for a single member company. So you have to be so keen, okay? So now, after looking at those, so far I've looked at a private company and its different categories. Then we have another type of a company, which is a public company, okay? The Companies Act, okay, defines under section 6, defines a public company to mean a company which is not a private company. So this means Yes, section 6 of the Companies Act. Okay, this means that this company does not restrict transfer of its shares. It has the number of its people is unlimited, so it is just there. Ayagala yakola ki yayingira. Okay, yes. Okay, so you should look at that, because that section was amended, but the amendment isn't fatal. So now, remember, so once you enter the panel, a question will come when it is directing you to that. So which type of company, what things do you look at and say, this is a partnership, this is a sole proprietorship, this is a company, this is a joint venture. If it is a company, it is a single member company, limited by shares, limited by guarantee, or a public company. Okay, so we presume that all that is. So now the presumption is you have chosen the appropriate form of a company you want to establish. Okay, the appropriate form of a company you want to establish. So then that takes us to what we call, okay, establishment of a company. Okay, establishment of a company. Okay, so how are you going to establish a company? Okay, so when you look at section 4 as amended, please mark this. The position we had in the Principal Act changed when we are incorporating a company. Okay, when you look at section 4 of the amendment, it says, okay, one or more persons may, okay, any one or more persons may incorporate a company with or without limited liability by filling in particulars contained in the registration form in the second schedule. What does that mean? Initially, the Principal Act said, okay, that anyone or more, okay, anyone or more persons may, for lawful purpose, incorporate a company by subscribing. So initially, subscription was sufficient, but here we incorporate a company by filling and filing what we call the registration form. So as a result of that, you have to go and look at the registration form. We have not yet cancelled, we've not yet started on the process. Okay. When you look at section 4, subsection 1A, okay, it says on filing of the form under subsection 1, if the registrar is satisfied that the applicant has complied with the provisions of this act, the registrar shall register the company and assign it a registration number. Okay, so but here this one talks about has satisfied or has complied with the provisions of the act. So that's what we want to first ascertain. When you go to the amendment, okay, that is form of application, which is known as company form 1. Okay, when you look at the particulars to be inserted in form 1, part 1, it has name of the company. So that means you cannot in any way fill in the registration form without, okay, without having a registration name. So that means the first requirement, okay, the first requirement in incorporating a company is coming up with the business name. Okay, So after that, you go to section 36 of the Companies Act, okay, which talks about search, reservation, and registration of a company name, okay. You'll appreciate that section 36 also prohibits registration of undesirable names and misleading names. So after you've come up with a business name which is not misleading, okay, and it is desirable, you make a search, reserve, and register the business name, okay. So at that point, if you have a business name, that's when you're going to come under section 4. Now you'll go and fill in what we call the registration form. Okay. You have to fill in the registration form. But this registration form is supposed to be accompanied by some documents. Why? Section 4 says that the applicant has complied with the provisions of the Act. So what things are you supposed to comply with? Those are the documents that accompany the application form. We go back to section 7 now. Okay. Section 7 talks about requirements with respect to the memorandum. Okay. So that means after the registration form, you've obtained it, you've filled it, you draft what we call the memorandum. Okay. But the memorandum alone is not sufficient. Section 7. Okay. So you've drafted the memorandum. Okay. Then after the memorandum alone is not sufficient. A memorandum is supposed to be accompanied by, you go to section 11, you also draft articles of association. Okay. But, okay, this memorandum, you cannot take it when it is not subscribed to. You go to section 8, signing of the memorandum. So the memorandum will be signed and the articles will also be signed. Okay. After signing, okay, then you will proceed and file for registration upon payment of what we call the registration dues. Okay. You shall pay the prescribed fees, okay, which are known as registration fees. Okay. These are provided for under which act? Okay, we have the Stamp Duty Act. So now we presume that you have complied with the provisions of section 11, 7, 8, and 4. Okay. You have complied with them. You've lodged for registration, and under section 4, subsection 2 and 3, the registrar is satisfied that you have complied with the provisions. Under section 4, subsection 3 as amended, the registrar will issue with what we call a certificate of incorporation. Okay. So now at that point, our company has been incorporated. Okay. Our company has been incorporated. So that means we have answered the question of how do we incorporate a company? Yes. Okay. Section 4, subsection as amended. Okay. It is section 4, subsection 1B. Okay. Okay. Are we together? So now, at this point, our company has been incorporated. Then ask you, we are going to our question 4. What are the effects of incorporating a company? What are the effects of incorporating a company? These are under the Companies Act as amended and at case law. Okay. When you look at section 4, (1)(c) of the Companies Act as amended, it has given us what we call the effects of incorporation. Okay. It says the company shall, from the date indicated in the certificate of incorporation, 1, be a body corporate. So the first effect is a company becomes a body corporate. Then 2, power to hold land. That means another one is capacity to own property. Then shall have perpetual succession. That means the third one is perpetual succession, capacity to sue and to be sued. That is also another effect. Okay. So the effects are under section 4, subsection 1(c). You can also refer to the case of Salmon versus Salmon. If not, you refer to the case of Lee versus Lee Air Farming Limited. Okay. Lee versus Lee Air Farming Limited. So now, section 4, subsection 1(c). Okay. So we are looking at the amendment. Please don't forget that. Okay. So now we've looked at the effects. Our company is standing now. We have registered our company, and now we've known that since we have registered, the following things happen. The company is distinct from its members and shareholders. But upon incorporation, the law requires that some things should be done. Okay, then that takes us to our next question, known as what are the different mandatory filings upon incorporation? What are the different mandatory filings upon incorporation? Okay. What are the different mandatory filings upon incorporation? Okay. Yes, Councillor Ronald, your hand is up. Kindly ask before we proceed.
I just wanted double confirmation from you. The form in the amendment of
Yes.
the Companies Act, it replaced those Form 20s and Form 18s.
Now those are what we call mandatory filings. They are under mandatory filings. So the procedure of registration changed after the amendment. So mark that.
So all those forms are brought. So right now you just submit this form and the memorandums and articles.
Yes.
After reservation of your name.
Yes, yes.
All right, merci beaucoup.
Okay. So we go on. So we are looking at what are the different mandatory filings. Okay. The first mandatory filing is under section 119. 119 is what we call the register of members. Okay. 119. Okay. Okay. Register of, it says that upon incorporation, the company shall maintain a register of its members. Okay. Then another mandatory filing is under section 119 capital A. Okay, 119 capital A. This is the amendment. When you look at the amendment, okay, it talks about an insertion immediately after section 119. So that means you also have to file what we call a register of beneficial owners. It is mandatory. So those things we are mentioning in the amendment, kindly put emphasis onto them. Okay, put emphasis onto them. Okay, a register of beneficial owners under section 119 capital A. Then another mandatory filing is what we call Form 18. Okay, this is commonly known as a notice of situation of business. Okay, look at section 116. Okay, notice of situation of business.
Council, pardon, I really didn't get a thing.
Okay, we've said this. The third one is what we call Form 18. This is commonly known as Form 18, but when you read the Act, it is referred to as the Notice of Situation of Registered Office. Okay, the Notice of Situation of Registered Office. So what that, because if you read the section, it is very clear, okay, and very express. Okay, the form has been forwarded because it says notice of situation of registered office and registered postal address of any change shall be given within 14 days from the date of incorporation. You see, it has the word shall. Everything we are looking at has the word shall. That's why it is called mandatory filings. Okay. Then another mandatory filing is known as a statutory report. Remember, upon incorporation of a company, it is required to convene what we call a statutory meeting. So as a result of that, okay, from a statutory meeting, we get a statutory report. When you look at section 137, it says that a company limited by shares and every company limited by guarantee and having a share capital shall, within a period of not less than 1 month or no more than 3 months from the date of its incorporation. Okay, 137. Okay, it shall convene a statutory meeting. Then subsection 3, subject to subsection 2, if a statutory report is forwarded. Okay, so that means once you come up with a statutory report, you have to file it because it is mandatory. Okay, then another one, we have what we call a return on allotment. Return on allotment, it is under section 61. Return on allotment. It says whenever a company limited by shares or a company limited by guarantee having a share capital makes an allotment of its shares, the company shall within 60 days deliver to the registrar for registration a return of allotment. Okay, what does this mean? Section 61. Remember, once you are registering a company, we have these guys who call themselves subscribers. What do they subscribe for? They subscribe to shares. Upon subscribing, they become shareholders because they have allotted themselves shares. So once a big company commences within 60 days, okay, we shall file what we call a return on allotment, stating how many shares we have, each share costs how much, and how many shares have been taken up, and how many shares have been paid up. Okay, so you should mark that. Okay, Are we together? Okay. Then we have another one, which is known as another mandatory filing is what we call annual returns. This is under section 132. Okay. This is filed at the end of the financial year. Your first year, you should file what we call annual returns. Okay. Those are, because you see, whatever we've been looking at has the word shall. And remember, I've said that the rules governing interpretation of the act, whenever I see the word shall, it means it is mandatory. So that's why they are referred to as mandatory filings. Okay. So you see how we've moved. Now we've filed our mandatory filings. Okay. Now our company is commencing business. How? They will also proceed and obtain what we call a trading license. Okay. So at that point, our company is already existing. We have complied with all the provisions of the law and we are commencing business. Okay. We are commencing business. Things have to change. Okay. For this company to succeed, it should have good management. So as a result of that, that takes us to what we call management of a company. Management of a company. Okay, so now when it comes to management, we shall deal with the following. Okay, under management, what you should ask yourself: one, okay, who does management of the company? Okay, this is a director. Okay, is a director. Okay, under this, we shall look at who is a director, different types of directors. How do we appoint a director? Powers and duties of a director, and then removal of a director. Okay. Because the director doesn't alone, we shall also look at the secretary, who is appointed by the director. So we shall look at their appointment and their duties and their removal. The director is answerable to the shareholders. Then we shall look at who is a shareholder, who is a member. Okay, so that will take us the transition from promoter, subscriber, shareholder, and a member. Okay. Then under the powers of shareholders, as we shall look at their rights, they have the power to appoint auditors. Then we shall look at also auditors. Okay, that will cover our management. Okay, then after management, we shall go to what we call dispatch of company business. How do we dispatch company business? Is by way of meetings. So we shall look at what is a meeting, different types of meetings, how do we call meetings? Those are the different notices and how to deal with them. And then after that, we shall look at what takes place in the meetings. That is what we call voting. When we are looking at voting, we shall look at voting, statutory and non-statutory. Statutory, we shall look at voting by proxies and voting by a poll. They are provided for under the law. Then we shall look at the non-statutory. Then after voting, the outcome voting is known as a resolution. Then we shall look at the different types of resolutions. That is board, special, and ordinary. So we shall look at under what circumstances, okay, do these resolutions, okay, operate. So we shall look at things that require board resolution, things that require special, things that require ordinary. Then we shall look at what we call registration of a resolution and its effect. Then lastly, we shall look at what we call capital financing. We look at equity finance and then, okay. So colleagues, allow us end here today, okay? It is approaching 6. We may not repeat this session, but tomorrow we are going to start a little bit early. We are completing company and we handle procurement and sale of goods. So tomorrow we are having 2 things at the same time. Inshallah, tomorrow we might be physical, okay? We shall see whether we can access LDC premises, okay? It is subject to clarification, okay? Any question from where we have stopped, okay? Any question from where we have stopped?
Council Rashid,
Yes?
kindly take us through the process of incorporating a company limited by guarantee.
It is the same council.
It is the same.
Because he said incorporation of a company. What is a company? A company means a company incorporated under the Companies Act. Yes.
So it is the same.
It is the same.
Much obliged.
Council Rashid.
Yes.
Maybe you help us take us through or you summarize the necessary documents to incorporate a company.
Okay. We have what we call the registration form. That is Form 1. Okay. Then after Form 1, we have Form 18. We have Form 20. We have also a list of proposed directors and secretaries, and the proof of payment of the necessary fees. Then also need memorandum and articles of association. Another question, Council? Yes. Any other question? Is everything well, comrades?
Maybe you didn't give us the information of a single member company.
So that process is the same. It is a company. That's what you should note. But the only change is that here you have to come up with what we call a list of nominee, okay, and alternate nominee. You have to file them. That's the only change.
Yes, Council.
Yes.
Council. I was
Yes.
asking how about a company limited by shares to a single member company. What could be the process?
Council shall go to that one. Don't worry. Because we have things that require special resolutions, re-registration, okay, and conversion. Those things require resolutions, Council.
Council, kindly, in summary, can you please guide me on the procedure of incorporating a company? Also, I wanted to ask, according to the question that was just asked previously, should we consider that even when it comes to foreign companies, establishing them in Uganda, we are going to wait till the next session?
Yes, Council, that requires a resolution as well. Because that one is not incorporation, is registration.
Okay, Council. My first question.
Okay, the process of incorporation is 1, you come up with a business name, you make a search, then 3, you reserve the business name, then 4, you register the business name, then 5, you fill in registration form 1, then you draft the memorandum and the articles of association, then you sign them, okay? Then you file the registration form together with the articles for registration, and then you pay the necessary fees and you file with the registrar of companies to register your company. If the registrar is certified that you have fulfilled the requirements, then they will issue with what we call a certificate of incorporation. Okay. Any other question? So let me wish you guys the best. Muslims, kindly prepare iftar, okay, and pray kindly, okay. Pray Taraweh today. We have completed in time. Let's use this time to talk to Allah. Let us pray for our colleagues. Let us pray for ourselves, okay. Allah will bless us. Surely He is the best, okay.
For me, let me book. You pray for me. Please.
Okay, Council.
Let me book.
Okay. Council,
Thank you so
kindly.
much.
Okay. Kindly inbox me, Miss Tugume. Okay.
Okay, please.
Okay.